to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss on the concept invitation for expression of interest EOI and shortlisting of prospective resolution applicants. So in the previous classes we have discussed once the application by financial creditor, operational creditor or corporate debtor is admitted by the NCLT, that is adjudicating authority, then resolution professional will be appointed, that is IRP will be appointed. Okay, COC, he is going to constitute the committee of the creditors. In the previous classes we have discussed the voting rights, powers of COC, who can be a member in the COC, who cannot be member in the COC, who is considered to be related party. So all these things we have discussed in the previous classes. Okay, so today we are going to discuss the concept of invitation for expression of interest. So once the resolution process started, this is considered to be one of the important step. Okay, so that is invitation for expression of interest. Whoever is interested, so we are going to invite them. Okay, so section 25 subsection 2 clause H of IBC deals with invitation for expression of interest, which provides that the resolution professional invite prospective resolution applicants who fulfill such criteria as may be laid down by him with the approval of committee of creditors, having regard to the complexity and scale of operations of the business of the corporate debtor and such other conditions as may be specified by the board to submit a resolution plan or plans. So section 25 subsection 2 clause H provides that so it is a responsibility, it is a duty of the resolution professional to invite prospective resolution applicants. So here, whenever he is inviting applications from the prospective resolution applicants, the resolution professional with the approval of the committee of the creditors, he is going to prescribe a criteria, eligibility criteria. So at least you are expected to have so and so turnover. Minimum quotation amount must be so and so crores. So like this, he is going to prescribe certain criteria. So this criteria is very complex in nature. Because we cannot generalize the things. Depending on the company nature, company size, the criteria will change. So that's why resolution professional, after considering the corporate debtor, that is company size, and other factors, related factors, with the approval of the COC, they are going to fix the criteria. So whoever is satisfying the criteria specified in the announcement, he is supposed to submit a resolution plan. So which is provided in section 25 subsection 2 clause H. Now from this you can understand that it is an obligation on RP to invite prospective resolution applicants. So here resolution professional is having an obligation to invite prospective resolution applications so that he can assess and COC can approve it. Subsequently, the resolution plan can be approved and CRP process can be completed. Then the important regulation is regulation 36A. So today mostly we are going to discuss regulation 36A only. So regulation 36A of CRP regulations. So regulation 36A, what is the importance? So regulation 36A of Insolvency and Bankruptcy Board of India, IBBA, insolvency resolution process for corporate persons. Generally, famously it is known as CRP regulations. Regulations sets out the procedure for inviting and processing expression of interest. So how to invite, then how to process the expression of interest from the prospective resolution applicants. So section regulation 36A speaks about two aspects. One is invitation, inviting and processing the expression of interest. So that is why it is very crucial step in the corporate insolvency resolution process. So in the CRP process, this is one of the crucial step. So as it helps identifying the potential bidders interested in taking over or reviving corporate debtor. So this is one of the crucial step. Why? Because this steps helps the company, that is corporate committee of the creditors, to identify who is interested in taking over the company, or else who is interested in filing an application, resolution plan. So to know who is interested taking over the company or else reviving the corporate debtor. That's why this process is very, very crucial in the CRP process. Then what is the purpose of regulation 36A? So this regulation ensures that a transparent and structured process. Okay, so if you in this lesson only we are going to discuss the entire process of regulation 36A. Okay, so from this you will understand that a transparent and structured process prescribed in regulation 36A. So that how to invite, how to take the expression of interest, how to take the application, how to scrutinize, then how to shortlist them, how to place them before the COC, then what COC is going to do subsequently. Okay, so the entire process is discussed in this regulation. Okay, so that's why this regulation ensures a transparent and structured process for inviting resolution applicants while adhering to strict timelines. Okay, so in the previous classes we have discussed the timelines. Okay, so timelines prescribed under the IBC code. Okay, so we had to follow the timelines. Apart from this, we have to follow the procedure also. Okay, so it helps in attracting serious and eligible applicants who can propose a viable resolution plan for the distressed company. Okay, so this is the purpose of regulation 36A. Now let us look at regulation 36A. Okay, so regulation 36A provides that what the manner in which duty of RP shall be performed. Okay, so how RP should perform his duties, it is mentioned in the regulation 36A of the CRP regulations. Okay, now in the case of EBIC Singapore Private Limited versus COC of Edu Company Solutions Limited. So in this case, the Supreme Court observed that so they have identified the important role of RP. Okay, why? Because he is the person who is going to replace the board of directors. So regulation 36A provides for the duties of RP, how he has to exercise certain duties. Okay, so in this judgment they have identified the role of RP and they have pointed out that it is the duty of the RP to solicit resolution plans. Okay, when he is inviting, when he is receiving, so through invitation he has to solicit resolution plans, and RP is empowered to invite prospective resolution applicants who fulfill the criteria as laid down by the resolution professional. Okay, so resolution professional is going to fix the criteria. But please remember, this criteria has to be approved by the COC. Okay, resolution professional cannot approve it. Resolution professional has to fix and it has to be approved by the COC. Then he is going to invite. Okay, then you are going to receive the applications and you are going to verify whether these applications are as per the criteria fixed or not. Okay, so that's why he is playing a crucial role in the CRP process. Okay, then in another case law, Amritavani Exim Private Limited versus Ajanta Offset and Packaging Limited. Packaging Limited. In this case, NCLT Delhi bench held that they have explained the stages of CRP process. Okay, I mean regulation 36A. So first you are going with the expression of interest. Okay, then subsequent to that you are going to receive the expression of interest. First you are going to announce. Whoever is interested, please give your expression of interest, public announcement. Then subsequent to that, you are going to receive the expression of interest. Then after receiving it, the RP, resolution professional, is going to conduct the due diligence. Okay, whether they are as per the rules or not, whether he is satisfying the eligibility criteria or not. So he is going to verify the applications. Okay. Then once that is done, he is going to issue the provisional list. Okay, provisionally these are all the people who are eligible to file resolution applications. Okay, then he is going to issue provisional list. Then subsequent to that, issue of information memorandum. So he is going to give issue of information memorandum, evaluation matrix. Okay, so request for resolution plan. Okay, these things will happen parallelly. Okay, so here please remember, evaluation matrix and information memorandum, they are very important for the resolution applicants. Why? Because based on the information memorandum and evaluation matrix only, they are going to give the resolution plan. Okay, then subsequent to that, he is going to request the resolution plan. Then issue the final list of prospective resolution applicant after considering the objections. Okay, so in the subsequent lessons we are going to discuss who are not eligible to file a resolution application. Okay, so and even resolution professional with the consent of COC, they are going to fix certain criteria. So they are going to verify whether everyone has satisfied the criteria or not. Okay, once that is done, and if any objections are there, after receiving the objections, they are going to issue the final list of prospective resolution applicant. Now we know who are all the people who are going to compete with each other to file a resolution application. Okay, then after that, submission of resolution plan. Okay, once the resolution plan is submitted, then they are going to examine the resolution plan. The resolution professional along with his other professionals. Okay, generally as per the law, he is having power to appoint various officers. Okay, so with the help of other officers, they are going to verify, examine the resolution plan. Then they are going to present it before the COC. Okay, then they will put for voting. So once it is done, subsequent events will happen. Okay, so these are all the various stages. Okay, how it will happen. Okay, it was explained in the case of Amritavani Exim Private Limited versus Ajanta Offset and Packaging Limited. Okay, Delhi bench NCLAT. It has laid down the stages. Okay, totally 8 stages are there. Okay, now let us look at the key provisions of Regulation 36A. So first one, expression of invitation for expression of interest. So the resolution professional must invite expression of interest from the potential resolution applicants. The invitation must be published in newspapers. So please remember, whenever they are talking about publication, the thumb rule is that you have to publish in one English newspaper and one in vernacular language in a place where the register office of the company is situated. Okay, while having wide circulation. Okay, so having wide circulation is a question mark. Okay, again. Okay, the resolution professional must invite expression of interest from the potential resolution applicants. The invitation must be published in newspapers and on the IBBA website. Okay, it must be issued within 75 days from the insolvency commencement date. The invitation should clearly specify the eligibility criteria. So when you are inviting, you should specifically state the eligibility criteria, what you are expecting and eligibility criteria. Then it has to be published in a newspaper and IBBA website also. Okay. Then contents of invitation. So let us discuss about the contents. The invitation must include, what should be there? Details of the corporate debtor. That is name, business activities, date of incorporation, industry, etc. etc. So why? Because when you are inviting, you should disclose about your company. Then only resolution applicants or prospective resolution applicants will come forward. Okay, so that's why you should disclose the corporate data. That is name, business activity, date of incorporation, industry structure. Okay, so everything. Then eligibility criteria for the applicants. Okay, maybe it can be eligibility criteria can be based on financial or it can be technical, it can be legal aspects. Okay, so what are all the eligibility criteria? Okay, so ensuring that only serious applicants can participate. Okay, so why we are prescribing the eligibility criteria? Because to ensure that so everyone is not participating. Okay, whoever is actually serious and whoever is having the eligibility criteria, only they should be participating. Otherwise what happens, you will end up receiving so many applications, they may not be useful. Okay, then last date for submission of expression of interest. Okay, so it should mention, but it should be at least 15 days from the date of invitation. Okay, when you are inviting the people, when you are going for expression of interest, minimum 15 days gap must be there. Okay, then penalties and disqualification. Any restriction applicable to applicants, including ineligibility under section 29A. So if section 29A is there, then is there any penalties are imposed or any restrictions are there? So these things must be included in the invitation. Okay, then other conditions, the EOI must be unconditional. Okay, the applicant must provide necessary undertakings and documents. So whenever if he is submitting, necessary undertakings are there. So subsequently we are going to look at the form level also. At the form level we are going to look at the form. So these things must be given. Okay, then submission of expression of interest. So once EOI is given, invitation is given, then expression of interest will be submitted. Okay, the interested applicants must submit their expression of interest before the deadline. So in the invitation we are going to give the deadline. So within that period you are supposed to submit the expression of interest. Okay, then this expression of interest must include that, so whoever is making an application, he is eligible or else he is having eligibility which is set out in the announcement. Because when you are inviting, you are prescribing the eligibility criteria. Okay, so eligibility criteria as prescribed by the COC and eligibility criteria, that is who are not eligible under section 29A. So these things must be satisfied. Okay, so you should give a declaration that applicant meets the eligibility criteria set by the RP. So RP is going to set the eligibility criteria in consultation with the COC and undertaking that you are complying with section 29A. So these things must be there. Okay, so which disqualifies certain applicants like promoters of defaulting company, undischarged insolvent. So certain categories of the people, they cannot make an application. Okay, so you have to give a declaration that I am not disqualified, I am having the eligibility. Okay, and any other additional information as may be required by the resolution professional, you are expected to give. Okay, then once that is done, okay, so then you are going to prepare provisional list. Okay, so RP prepares a provisional list of eligible applicants within 10 days. Okay, once the expression of interest submission of deadline is completed, so within 10 days he is supposed to prepare the provisional list. Okay, so any applicant who is excluded from this list can raise objection within 5 days. So if someone is excluded, so even provisional list will be made public. Okay, so if someone is having any objection, within 5 days he can raise the objection. Okay, so after considering the objection, the final list of eligible applicants is published within 10 days. Okay, so then subsequent to that, how to publish? So in one of the case law, there is Dr. Periyasamy Palani Gounder versus Mr. Radhakrishnan Dharmarajan RP Appu Hotels Limited. So in this case law, NCLJD held that the publication must be done in form number G. Okay, so we are going to look at the form number G also. So please remember, publication of form number G is mandatory. Okay, so if you fail to publish in form number G, it amounts to material irregularity. Okay, so in this case law, it was held that form G is mandatory. You cannot escape from the form G. Okay, then you are supposed to do the publication in form G. We will look at the form number G. Okay, then you should not be disqualified under section 29A. Okay, so let us look at the form number G. This is form number G. Invitation for expression of interest for name of the corporate debtor, operating industry type at locations. Okay, so this is the relevant information. Okay, name of the corporate debtor along with the PAN, address of the registered address, URL of the website, details of place where the majority of the fixed assets are located, installed capacity of the main products. Okay, suppose if thermal power project is there, then you are supposed to state the installed capacity. Cement industry is there, installed capacity. Okay, then quantity and value of main products, services sold in the last financial year, and number of employees and workmen, how many employees are there. Further details including last available financial statements, okay, with schedules of 2 years. List of creditors. Okay, so this list of creditors must be uploaded, then URL must be given here. Then eligibility for resolution applicant, who is eligible, maybe financial eligibility, technical eligibility, you have to state here. Okay, then last date for receipt of expression of interest, then date of issue of provisional list, last date for submission of objections to provisional list if any, then date of issue of final list of prospective resolution applicants, date of issue of information memorandum. So once the final list is completed, then you are going to give the information memorandum, evaluation matrix, request for resolution plan. Okay, so based on the information memorandum, evaluation matrix, the prospective resolution applicants, they are going to submit the resolution plan. Okay, then last date for submission of resolution plan and process email ID to submit the expression of interest. Okay, so these are all the basic data to be given in form number G. Now let us discuss about detailed invitation. Okay, regulation 36A(4). Okay, so duties of RP. Okay, so section 25(2)(h) provides that he is supposed to invite prospective resolution applicants who fill such criteria as may be laid down by him with the approval of the committee of the creditors. As already we have discussed, regulation 25 section 25(2)(h) provides that. Okay, so whoever is fulfilling the criteria, he has to invite applications from them. Okay, then having regard to the complexity and scale of operations of business of the corporate debtor and such other conditions as may be specified by the board to submit a resolution plan. Okay, so regulation 36A(4) provides that the resolution professional is having the duty to invite prospective resolution applicants, whoever is fulfilling the criteria, and also whoever is not disqualified under section 29A. Okay, then in one of the case law, that is Mr. C. Raja John versus Mr. R. Raghavendran RP of Springfield Shelters Private Limited. So in this case, the NCLJD held that the RP can lay down certain criteria for inviting the prospective resolution applicants who fulfill such criteria. Okay, so RP is going to fix the criteria, and please remember this criteria must be approved by the COC. So whoever is satisfying the criteria or whoever is fulfilling the criteria from them only they are going to receive the applications. Okay. Then in another case la, Binani Industries Limited versus Bank of Baroda, NCLAT held that the COC, RP, resolution applicants are bound by the process documents prepared under section 25(2)H. Because under section 25(2)H, you are going to give invitation. So where you are going to state the eligibility criteria and other details. Okay, so what should be satisfied, etc., etc. Okay, so once based on the invitation, if someone is giving the expression of interest and someone is submitting the resolution plan, if it is approved by the COC, then the COC, RP, resolution applicant, everyone is bound by the process documents. Okay, whatever is prepared under section 25(2)H. Okay. Then whether COC is having power to modify an invitation for expression of interest, yes. Okay, so under regulation 36A, 4A of the CRP regulations, which provides that any modification in the invitation for expression of interest may be made in the manner as the initial invitation for expression of interest was made, provided such modification shall not be made for more than once. Okay, so can you make the changes? Yes, you can modify. Okay, so how you are going to prepare the original document, that is original invitation, in the same manner you can prepare the modified version also, but this modification cannot be done for more than once. Okay, so only once you are having the option to change the or modify the invitation for expression of interest. Okay, then prospective resolution applicants, regulation 36(5). So in the case of Amit Gupta versus Yogesh Gupta, RP, and in another case Rakhi Agencies Limited versus Hemant Sharma, RP for White Medals Limited, NCLAT held that the time limitation, the timeline for submission of EOI cannot be extended. Okay, so in invitation only you have given the time limitation. Okay, so this cannot be extended. Okay, so once, suppose if someone submits the resolution application subsequent to that, if you receive after stipulated time limitation, then it has to be rejected. Okay, so you have to stick to the limitation period. Okay, so if any submission is made after the time limitation, okay, prescribed in the invitation, please remember you are supposed to reject the application. Okay, then the manner in which expression of interest should be submitted. Okay, so till now we have discussed how to give the invitation. Okay, then once the invitation is done, how to submit the expression of interest. Okay, so regulation 36(6), 36A 7 provides for this. Okay, so 36A 7 provides that an undertaking by the prospective resolution applicant that it meets the criteria specified by the committee of the creditors. So when he is giving expression of interest, he should give a declaration or he should give an undertaking that he is satisfying the eligibility criteria and he is not disqualified under section 29A also. Okay, then relevant records in evidence of meeting the eligibility criteria. So suppose if you are fixing eligibility criteria as financial eligibility criteria, okay, having the turnover, then you have to submit the evidences stating that you are having the turnover. Maybe latest audited financial statements, you can submit it. That becomes the relevant evidence. Okay, so relevant records of evidence must be submitted along with the expression of interest. Okay, and undertaking by the prospective resolution applicant that it does not suffer from the ineligibility. So please remember, whenever you are submitting EOI, expression of interest, one thing that you have to state is you are eligible, and another thing that you have to state is you are not disqualified under section 29A. Okay, so these two things must be satisfied, and when you are stating that you are eligible, you are supposed to give the evidences for that. Okay, then relevant information and records to enable the resolution professional to evaluate, these things must be included. Okay, then an undertaking by the prospective resolution applicant that it shall intimate the resolution professional forthwith if it becomes ineligible. So please remember, now when you are giving expression of interest, you are eligible or else you are not disqualified. Suppose in the near future if you becomes disqualified, then you should give an undertaking that, okay, prospective resolution applicant, you should give an undertaking that if he becomes ineligible at any time during the CRP process, he should intimate the resolution professional. Okay, then he should give an undertaking that is prospective resolution applicant, that every information or records provided in expression of interest is true to the best of his knowledge. Okay, and he is giving the true information and correct information, and discovery of any false information or record at any time will render the application ineligible. So subsequently, if it is proved that any information is false information is given, then he becomes ineligible. So he is giving undertaking that I am ready to be ineligible. Okay, then he should give an undertaking by the he should give an undertaking that it shall maintain confidentiality. Why? Because when you are filing an application, subsequently you are going to receive a lot of information from the company, which may be confidential information. So you should give an undertaking that you are not going to use such confidential information with any person. Okay, so you are not going to share this information, and you are not supposed to gain any undue advantage. Okay, so maybe cause an undue gain or undue loss to itself or any other person. Okay, so why? Because you are not supposed to disclose information. These are all confidential information. Okay, so generally we prefer to have NDA agreement, also non-disclosure agreement here, so that no resolution applicant, prospective resolution applicant is going to disclose the information which he received as a part of the resolution process. Okay, then obligations of the resolution professional to conduct the due diligence. So once if he receives the expression of interest, then subsequent to that he is supposed to do the due diligence. Okay, what he is supposed to do? Regulation 36A8, which provides that the resolution professional shall conduct the due diligence based on the material information or material on the record in order to satisfy that the prospective resolution applicant complies with provisions of section 2H, 25-2H, that is he satisfying the eligibility criteria. So how to verify? So based on the application made by him, you just verify the financial statements given by him, whether is he satisfying the financial requirements or turnover requirement, capital requirement, or eligibility criteria in relation to technical. Is he having the technical eligibility? So please verify. Okay, then whether is he disqualified under section 29A, please verify, or other requirements as may be specified in the invitation. Okay, so these data he has to verify. Okay, for due diligence, anywhere he is supposed to whenever if he require any further information, he can ask the prospective resolution applicant to submit the further information as may be required. Okay, then in one of the case law, there is ArcelorMittal India Private Limited versus Satish Kumar Gupta. So in this case, the Supreme Court held that the RP shall undertake to present all resolutions plan at the meeting of COC. Okay, so please remember, once after receipt of the expression of interest applications, okay, the RP shall do the due diligence. Once the due diligence is completed, then he should present all the resolution plans before the COC. Okay, then opinion in another case law, Sharavan Kumar Vishnoy versus Upma Jaiswal, NCLAT held that the opinion of RP is only prima facie and preliminary in nature. Why? Because based on the due diligence, he must be forming some opinion, professional opinion. This opinion is only prima facie opinion. Okay, so it has to be placed before the COC. The commercial wisdom of the COC is final. So the decision is to be taken by the COC only. ROC cannot take any decision. ROC is there only to verify, conduct the due diligence, submit the resolution plans, all the resolutions plans, place it before the committee of the creditors. Then committee of the creditors, they are supposed to take the decision. Okay. So regulation 36A10. The resolution professional shall issue provisional list of eligible prospective resolution applicants within 10 days of the last date for submission of expression of interest. So once if you receive the expression of interest, then you are supposed to prepare the provisional list. Okay, then subsequent to that, regulation 36A11 provides that any objection to the inclusion or exclusion of prospective resolution applicant in the provisional list referred in subregulation 10 may be made with supporting documents within 5 days. So within 10 days, he is going to issue the provisional list. Then within 5 days, if any objections are there, you can raise the objection on the provisional list. Then 36A12 provides that on considering the objections received under subregulation 11, the resolution professional shall issue final list of prospective resolution applicants. Okay, so once the expression of interest is completed, then provisional list is done, objections are received, then you are going to prepare the final list. Okay, so final list within 10 days of the last date of receipt of objections to the committee. Okay, so the list is ready, then you are going to invite them to give the resolution plans. Let us recap what we have discussed today. In today's session, we have discussed about the invitation for expression of interest, how to give the invitation for expression of interest, Then we have discussed about Regulation 36A of CRP regulations in detail. And what is the purpose of Regulation 36A? Why this regulation was introduced? We have discussed. Then the key provisions of the Regulation 36A we have discussed today. Then we have discussed about the contents of invitation. So whenever you are giving the invitation for expression of interest, so what should be the contents in the invitation we have discussed. Then we have discussed the provisions relating to submission of expression of interest. Then we have discussed the provisions relating to provisional and final list of resolution applicants. Then how resolution professional is expected to prepare the provisional and final list of resolution applicants we have discussed. Then we have discussed about power of COC to modify an invitation for expression of interest. So we have discussed the question of whether COC is having power to modify the invitation. That means once the invitation for expression of interest is given, whether COC is having power to modify the terms and conditions, modify the contents of the expression of interest or not, we have discussed. So we discussed that yes, COC is having power to modify the invitation for expression of interest. Then subsequent to that, we have discussed the obligations on the RP to conduct the due diligence. So whenever he is giving the resolution professional is giving the expression of interest, that is invitation for expression of interest, and whenever he is receiving the expression of interest from the prospective resolution applicants, he is expected to conduct the due diligence. So with this, in today's lesson, we have discussed the concept of invitation for expression of interest and shortlisting of prospective resolution applicants. Thank you.